Hello, my aspiring real estate agents. Do you want to learn about legal and regulatory requirements of the real estate business? Great, then you're at the right place today. I'm Farrah, your real estate business coach, and I'm so thrilled to have you all here today. In this video, we are going deep into an essential aspect of the real estate business that you as a real estate agent need to know about legal and regulatory requirements. Now, I know these terms might sound a bit confusing, but don't worry. I'm here to break them down to you in a very simple language. This video will help you whether you are just starting your real estate agency or looking to sharpen your real estate expertise and skills. Understanding these key aspects will make you more confident and compliant real estate agent. So if you're ready to gear up your legal game and build a thriving real estate business in India, then I'm sure you're at the right place to do so. Before we dive in, hit the like button and subscribe to my channel so you won't miss any future tips and insights. If already subscribed, then hit the bell icon to get notified of the new videos. Okay. Alright then, let's dive into detailings. Why legal and regulatory requirements the most important to know and follow? There are many reasons why legal and regulatory requirements in the real estate business are most important to know and follow. Here are the few most important reasons are to protect your clients by knowing the following and the legal regulatory requirements. You can help to protect your clients from very unethical developers and agents. You can also help to ensure that your clients' transactions are completed smoothly and they are not exposed to any legal risk. To protect yourself by knowing and following the legal and regulatory requirements, you can protect yourself from the legal liability. If you violate the law, you could be sued by your clients or by any other parties. To maintain your professional reputation by knowing and following the legal and regulatory requirements, you can maintain your professional reputation. If you are seen as a reputable and trustworthy agent, you will be more likely to attract new clients and to retain your clients with the many referrals. To comply with industry standards, the real estate industry is governed by number of industry standards. By knowing and following these standards, you can demonstrate that you are a professional who is committed to provide the highest level of service to your clients. In addition to this reason, there are a number of other benefits too, knowing and following the legal and regulatory requirements in the real estate business. For example, by knowing the law, you can be more proactive in identifying and resolving potential problems. You can also be more effective in negotiating on behalf of your clients. Overall, there are many good reasons why legal and regulatory requirements in the real estate business are most important to know and follow. Time to learn about the law. You can protect yourself, protect your client, and maintain your professional reputation and comply with industry standards. Here are some additional tips for real estate agents who wants to stay compliant with the law. Stay up to date on the latest legal and regulatory changes. The law is constantly changing, so it is important to stay up to date on the latest changes. You can do this by subscribing to a legal newsletter, attending industry events, and reading trade publications. Consult with attorney. If you have any questions about the law, it's always a good idea to consult with an attorney that can help you to understand your legal obligation and to ensure that you are complying with the law. Be proactive. Don't wait until there is a problem to start thinking about this law. Be proactive and take steps to ensure that you are complying with the law. This will help you avoid problems down the road. By following these tips, you can also help to ensure that you are staying compliant with the law and you are providing the best possible service to your client. Well, this is all about why it is important to know about legal and regulatory requirements in the real estate business. Now your question would be how to learn to know about legal and regulatory requirements. Here I have simplified to you. Okay, here are some ways to know in details about legal and regulatory requirements. Consult with the lawyer or real estate attorney. A lawyer or a real estate attorney can help you understand the specific legal and regulatory requirements that apply to your real estate business in your country. Read government regulation. Government websites can often have information about the legal and regulatory requirements that apply to real estate businesses. You can also find this information in government publications such as the Code of Federal Regulation, that's called CFR in the United States. Attend real estate industry events. Real estate industry events often feature speakers who discuss the legal and regulatory requirements that apply to real estate businesses. This is a great way to learn about the latest changes in the law and to network with other real estate professionals. Join a real estate trade association. Real estate trade association can often provide their members with information about the legal and regulatory requirements that apply to real estate businesses. They may also offer educational programs and resources to help their members to stay up to date on the latest changes in the law. Subscribe to the real estate industry publications. Real estate industry publications often features articles about the legal and regulatory requirements that apply to real estate businesses. This is a great way to stay informed about the latest changes in the law and to learn about the best practices in the real estate industry. Following these tips, you can learn about the legal and regulatory requirements that apply to your real estate business to ensure that you are in compliance with the law. Here are some additional resources that you may find helpful. The National Association of Realtors, NAR. The NAR is a trade association that presents real estate professionals in the United States. The NAR website has a section on legal and regulatory resources for real estate professionals. The Real Estate Institute of Australia, REIA. The REIA is a trade association that represents real estate professionals in Australia. The REIA website has a section on legal and regulatory resources for real estate professionals. Canadian Real Estate Association, it's called CREA, CREA. The CREA is a trade association that represents real estate professionals in Canada. The CREA website has a section on legal and regulatory resources for real estate professionals. This is how you can know or learn about legal and regulatory requirements. If you don't want to go all the way there, then I'm here sharing with you all. What are the legal and regulatory requirements while building your real estate agency and in the real estate businesses? Okay. As a real estate agent or agency owner in India, it is essential to be aware of these various legal and regulatory requirements to ensure compliance, protect your clients, and build a successful and reputable real estate businesses. Here are some key legal and regulatory aspects to consider. Number 1, Real Estate Regulation and Development Act 2016. It's called RERA. Real Estate Regulation and Development Act 2016. It is a comprehensive legislation in India that aims to regulate the real estate sector, protect the interest of home buyers, and promote transparency and accountability in the industry. The RERA Act establishes a Real Estate Regulatory Authority, RERA, in each state for regulation of the real estate sector and also act as an educating body for speedy dispute resolutions. The RERA Act applies to all real estate projects including residential, commercial and industrial projects. The RERA Act requires all the real estate developers to register their project with the RERA in their respective states. The registration process is mandatory and failure to do so can result penalties. The RERA Act also requires real estate developers to provide certain information to home buyers such as project plan, the terms and condition of the sale and the completion schedule. The RERA Act also gives home buyers the right to withdraw from a project within 7 days of the signing agreement for sale. The RERA Act is also a significant step towards improving transparency and accountability in the real estate sector in India. It is also a valuable tool for home buyers to protect their interest. Here are some of the key features of RERA Act. Establishment of RERA regulatory authorities, RERAs in each state. The RERA Act establishes in each state or regulation of the real estate sector. The RERA is responsible for registering real estate projects, monitoring the process of projects and resolving disputes between the developers and home buyers. Registration of the real estate projects. The RERA Act requires all real estate projects to be registered with the RERA in their respective states. The registration process is mandatory and failure to do so can result in penalties. Provision of information to home buyers. The RERA Act requires real estate developers to provide certain information to home buyers such as project plan, the terms and condition of the sale and then the completion schedule. This information must be provided in a clear and a transparent manner. Rights of home buyer. The RERA Act gives home buyers certain rights such as the right to withdraw from the project within 7 days of signing the agreement for sale, the right to get timely possession of the property and to get right in compensation in case of delays or defects in the project. Dispute resolution mechanism. The RERA Act provides a mechanism for resolving disputes between the developer and the home buyers. The RERA has the power to adjudicate disputes and issue orders that are binding on both properties. The RERA Act is comprehensive legislation that aims to protect the interest of home buyers and promote transparency and accountability in the real estate sector. It is a very valuable tool for home buyers to protect their interests and ensure that they get a fair deal. The registration process is mandatory and failure to do so can result in penalties. Here is how you can do it in 6 steps. Step 1. Register with the Real Estate Regulation Authority, that's called RERA, in your respective state. Step 2. Provide the required information and documents to RERA. Step 3. Pay the registration fee. And step 4. Obtain a registration certificate from RERA. Step 5. Display your registration certificate on your website and office premises. And step 6. Comply with the provision of the RERA Act. Transfer of Property Act 1882. The Transfer of Property Act of 1882 is an Indian legislation that regulates the transfer of property in India. It contains specific provisions regarding what constitutes a transfer and a condition attached to it. It came into force on 1st of July 1882. The Transfer of Property Act of 1882 defines a transfer of property as an act of which living person conveys property in present or in future to one or more other living persons or to himself and one more or other living persons. The Act also sets out the different types of transfers that are possible such as sales, gift lease, mortgage and easement. It also provides for the requirement that must be met for a transfer to be valid, such as the consent of all the parties involved and the registration of the transfer with the relevant authorities. The Transfer of Property Act 1882 is an important piece of legislation for a real estate agents in India, as it governs many of the transactions that they will be involved in. So that's why the real estate agents should be familiar with this provision of the Act in order to advise their clients on their legal rights and obligations. Here are some of the key provisions of the Transfer of Property Act of 1882. Types of transfers. The Act defines different types of transfers such as the sales, gift lease, mortgage and easement. Requirement for a valid transfers. The Act sets out the requirements that must be met for a transfer to be valid, such as the consent for all the parties involved and the registration of the transfer with the relevant authorities. Rights and obligation of the parties. The Act sets out the rights and obligation of the parties to transfer such as the rights to possession of the property and the right to receive rent. Dispute resolutions. The Act provides for the resolution of dispute arising out of transfers such as through the courts or through arbitrations. The Transfer of Property Act of 1882 is a complex piece of legislation, and real estate agents should seek legal advice if they have any questions about its provisions. Here are the 6 steps. Step 1. Understand the different type of property transfers. Step 2. Be familiar with requirement for each type of property transfers. Step 3. Be available to advise your clients on the legal rights and obligations. Step 4. Be able to prepare the necessary documents for property transfers. And step 5. Be able to register property transfer with the relevant authorities. Step 6. Be able to follow up on property transfer to ensure that they are completed smoothly. Okay, now look into Indian Easement Act of 1882. The Indian Easement Act of 1882 is a law that governs the right of easement in India, and easement is a right that one property owner has over another property. This right allows the dominant owner to use the servient owner's property for a specific purpose, such as crossing the servient owner's property to access owner's property. The Indian Easement Act of 1882 defines easement and sets out the rule for how they can be created, transferred and extinguished. The Act also provides for the enforcement of easements and the remedies available to dominate and servient owners. Some of the key provisions of the Indian Easement Act of 1882 include type of easements. That Act recognizes 2 main types of easements: affirmative easements and negative easements. Affirmative easements allows the dominant owner to use the servant owner's property for specific purpose, such as crossing the servant owner's property to access their own property. Negative easements prevent the servant owner from using the property in a certain way, such as preventing them from building a fence on their property that would block the dominant owner's view. Creation of easement. Easements can be created in a number of ways, including by express grant, implied grant, prescription and necessities. Express grants are created by written agreement between the dominant and servant owners. Implied grants are created when the dominant owner has been using the servant owner properties for a certain purpose for a long period of a time without the servant owner's objections. Prescriptions is a way to acquiring an easement by using the servant owner's property for a certain purpose for a specified period of time. Necessity is a way of acquiring an easement when the dominant owner needs to use the servant owner's property in order to have access to their own property. Transfer of easements. The easements can be transferred in number of ways, including by sale, gift, or inheritance. When an investment is transferred, the new owner takes on all of the rights and obligation of the old owner. Extinction of easements. Easements can be extinguished in a number of ways, including by release, merger, abandonment, and prescriptions. The release is when the dominant or a servant owner gives up their rights to the easement. The merger is when the dominant and the servant properties are merged into a single property. Abandonment is when the dominant owner ceases to use the easement for a period of time. Prescription is a way of extinguish an easement by not using it for a specified period of time. The Indian Easement Act of 1882 is an important law that governs the rights of easement in India. By understanding the provision of this act, real estate agents can help their clients to protect their rights and interests in relation to the easement. So here are the 6 steps. Step 1. Understand the different type of easements. Step 2. Be familiar with the requirements of each type of easements. Step 3. Be able to advise your clients on their rights and obligations in relation to easements. Step 4. Be able to prepare the necessary documents for easements. And step 5. Be able to register easements with the relevant authorities. And step 6. Be able to follow up on easements to ensure that they are completed smoothly. Okay, now let's move to Registration Act of 1908. The Registration Act of 1908 is an act of Parliament of India that governs the registration of documents relating to immovable property in India. The act was enacted in 1908 and has been amended several times since then. The Registration Act of 1908 defines what document must be registered and the procedure for the registration. The Act also specifies the consequences of the failing registration of a document. Documents that must be registered under the Registration Act of 1908 include transfer of immovable properties such as sale deed, gift deed, and lease deeds. Mortgage of immovable property, wills relating to immovable property, power of attorney relating to immovable property. The procedure for registration under the Registration Act of 1908 is as follows. The document must be presented to the registering officer. The registering officer will examine the document to see if it is the one that is required to be registered. If the document is required to be registered, the registering officer will register the document and issue a certificate of registration. The consequences of the following to register a document under the Registration Act of 1908 vary depending on the type of documents. For example, if it's a sale deed, it's not registered, the buyer may not be able to prove their ownership of the property. The Registration of Act 1908 is an important piece of legislation that helps to protect the rights of the property owner in India. By registering documents, property owners can ensure their rights are probably documented and that they are protected in the event of dispute. Here are some additional key points about the Registration Act of 1908. The Act applies to all immovable property in India, regardless of the state in which it is located. The Act is administered by the Registrar General of India, who is appointed by the central government. The Act has been amended several times since it was enacted in 1908. The latest amendment to the Act was made in 2001. Here are 6 steps. Step 1. Understand the different types of documents that needed to be registered. Step 2. Be familiar with the requirements for registering documents. Step 3. Be able to prepare the necessary documents for registration. Step 4. Be able to register documents with the relevant authority. Step 5. Be able to follow up on registration and to ensure that they are completed smoothly. And step 6. Be able to advise your clients on the implication of not registering documents. Indian Stamp Act 1899. The Indian Stamp Act of 1899 is legislation that was enacted by the British Raj to levy stamp duty on documents in India. The act is still in the force today and to administered by the respective state governments. The Indian Stamp Act of 1899 defines the different types of documents that are chargeable with stamp duty and the rates of stamp duty payable. The Act also prescribes by the manner in which the stamp duty is to be paid. There are two types of stamp duty that are used in India: adhesive stamp duty and impressed stamps. Adhesive stamps are affixed to documents while impressed stamps are stamped on documents. The Indian Stamp Act of 1899 is a complex piece of legislation and there are many nuances to it. However, the basic principles of the Act are relatively straightforward. Here are some of the key provisions of the Indian Stamp Act of 1899. The documents that are chargeable with stamp duty. The Indian Stamp Act of 1899 lists the different types of documents that are chargeable with the stamp duty. These includes documents such as sales deed, lease deed, mortgage deeds, power of attorney documents and wills. Rates of stamp duty. The Indian Stamp Duty Act of 1899 prescribes the rate of stamp duty payable on different types of documents. The rate of stamp duty vary depending on the value of the property or the amount involved in the transactions. Manner of paying stamp duty. The Stamp Duty Act of 1899 prescribes the manner in which stamp duty is to be paid. Stamp duty can be paid at designated stamp duty offices or through online payment gateways. It is important for real estate agents to be familiar with Indian Stamp Act 1899 as they may be required to advise the clients on the stamp duty implications of the real estate transactions. Here are some tips for real estate agents who are dealing with stamp duty. Be familiar with the different type of documents that are chargeable with the stamp duty. Know the rates of stamp duty payable on different types of documents. Advise your clients on the stamp duty implication of the real estate transaction. Make sure that your clients pay the correct amount of stamp duty. Keep a record of all stamp duty payments by following these tips. Real estate agents can help to ensure that their clients comply with the stamp duty requirements and avoid any penalty. Here are the 6 steps. Step 1. Understand the different types of documents that require stamping. Step 2. Be familiar with the rates of stamp duty. Step 3. Be able to calculate the amount of stamp duty payable. And step 4. Be able to arrange for the payment of stamp duty. And step 5. Be able to advise your clients on the implication of not paying stamp duty. Step 6. Be able to keep a record of all stamp duty payments. Now it's very important is Code of Conduct for Real Estate Agents. The Code of Conduct for Real Estate Agents is set for all ethical standards that real estate agents are expected to adhere to. The Code of Conduct is designed to protect the interest of consumers and to ensure that real estate transactions are conducted in a fair and transparent manner. The Code of Conduct covers a wide range of topics including honesty and transparency. Real estate agents must be honest and transparent in their dealings with clients. They must provide accurate and up-to-date information about the properties and must not mislead clients in any way. Fairness and impartiality. Real estate agents must treat all the clients fairly and impartially. They must not discriminate against clients on the basis of race, religion, gender, or any other protected characteristics. Confidentiality. Real estate agents must keep all the confidential information about their client confidential. They must not disclose their information to anyone else without the client's consent. Professionalism. Real estate agent must behave in a professional manner at all times. They must be courteous and respectful to their clients and to other professionals in the real estate industry. Compliance with the law. Real estate agents must comply with all applicable law and regulations. This include the Real Estate Regulation and Development Act of 2016, RERA, the Transfer of Property Act of 1882 and the Indian Stamp Act of 1899. The Code of Conduct is enforced by the Real Estate Regulatory Authority, RERA, in each state. Real estate agent who violate the code of conduct may be subject to disciplinary action, including suspension or revocation of their license. Here are some of the benefits of complying with the code of conduct. Protects the interest of consumers. That code of conduct helps to protect the interest of consumers by ensuring that they are treated fairly and honestly by the real estate agents. Enhance the reputation of the real estate industry. The code of conduct helps to enhance the reputation of the real estate industry by demonstrating the real estate agent are committed to ethical standards, reduces the risk of legal liability. Real estate agents who comply with the code of conduct are less likely to be subject to a legal liability. Improves the efficiency of the real estate market. The code of conduct helps to improve the efficiency of the real estate market by reducing the risk of fraud and abuse. So, here are the 6 steps for this. Step 1. Familiarize yourself with the code of conduct. Step 2. Comply with the code of conduct in your dealings with client. And step 3. Be able to advise your client on the code of conduct. And step 4 will be able to report any breaches of the code of conduct to the relevant authorities. 5. Be able to take disciplinary action against any real estate agent who breached the code of conduct. And step 6. Be able to promote the code of conduct within the real estate industry. Real Estate Investment Trust REIT regulations. The Real Estate Investment Trust REIT is a company that invests in income producing real estate. REITs are traded on the stock exchanges and they offer investors the opportunity to invest in the real estate without having to purchase an individual properties. The Securities and Exchange Board of India (SEBI) has issued regulation governing REITs. These regulations set out the requirements that REITs must meet in order to be listed on the stock exchanges. The regulation also govern the activities of REITs, such as the types of property that they can invest in and the way they must distribute income to shareholders. Here are some of the key requirements of the REITs regulation. REITs must have at least 75% of their assets invested in income producing real estate. REITs must distribute at least 90% of their taxable income to shareholders. REITs must be listed on the stock exchange. REITs must have minimum of 200 shareholders. REITs must appoint a trustee to oversee their activities. The REIT regulations are designed to protect investors and to ensure that REITs are well managed. By complying with this regulation, REITs can provide investors with the safe and profitable way to invest in real estate. Here are some of the benefits of investing in REITs. REITs offer investors the opportunity to invest in real estate without having to purchase an individual property. REITs also trade on stock exchanges, which can make them liquid and easy to trade. REITs offer investors the potential for high returns, and REITs are relatively low risk investments. If you are considering investing in REITs, it's important to do your research and to understand the risk involved. However, if you are looking for a safe and a profitable way to invest in real estate, REITs can be a good option. Here are 6 steps. I'll tell you why. Step 1. Understand the REITs regulation issued by the Securities and Exchange Board of India (SEBI). Okay, and step 2 will be able to advise your clients on the benefits of investing in REITs. And step 3, be able to help your clients purchase REITs units. And step 4, be able to track the performance of REITs. And step 5, be able to advise your clients when to sell their REITs units. And step 6 will be able to comply with the REIT regulation in your dealings with client. Okay, let's move to Binami transaction. It's very interesting. Okay, Prohibition Act 1988. The Binami Transaction Prohibition Act of 1988 is an act of the Parliament of India that prohibits Binami transactions. The Binami transaction is a transaction in which property is transferred to one person for considering paid by another person. The Act defines the terms of Binami as follows. Binami means in relation to property that the property is held by one person for the benefit of another person, whether or not the person for whose benefit the property is held is unidentifiable at the time of the transaction. The Act prohibits Binami transaction and provides for the confiscation of Binami property. The Act also provides for penalties for person who is entered into Binami transactions. The objective of the Binami Transaction Prohibition Act of 1988 is to prevent the use of Binami transaction for money laundering and other illegal activities. The Act also aims to protect the interest of bona fide purchasers of the property. Here are some of the key provisions of the Binami Transaction Prohibition Act of 1988. The Act defines the terms Binami and prohibits Binami transaction. The Act provides for the confiscation of Binami property. The Act provides penalties for person who enters into Binami transaction. The Act establishes an authority to hear and decide cases relating to Binami transactions. The Binami Transactions Prohibition Act of 1988 is an important piece of legislation that helps to prevent money laundering and other illegal activities. The Act also protects the interest of bona fide purchasers of property. Here are the 6 steps. Step 1. Understand the Binami Transaction Prohibition Act of 1988. Step 2. Be able to identify Binami transactions. Step 3. Be able to report any Binami transactions to the relevant authorities. Step 4. Be able to take disciplinary action against any real estate agent who are involved in Binami transactions. Step 5. Be able to promote awareness of the Binami Transaction Prohibition Act 1988 within the real estate industry. And step 6. Be able to comply with the Binami Transaction Prohibition Act of 1988 in your dealings with the clients. Environmental Protection Act 1986. The Environmental Protection Act 1986 EPA is an act of the Parliament of India enacted in May 1986 and came into force on 19 November 1986. It has 26 sections and 4 chapters. The act is widely considered to have been a response to the Bhopal gas leak. The EPA is a comprehensive environmental law that sets out the framework for the protection of the environment in India. It provides for the establishment of the Central Pollution Control Board (CPCB) and State Pollution Control Boards to oversee the implementation of the Act. The EPA also empowers the government to take a number of measures to protect the environment, including setting standards of air, water and noise pollution, prohibiting the use of hazardous substance, regulating the disposal of waste, enforcing environmental impact assessments. The EPA is an important piece of legislation that has helped to improve the environmental quality in India. However, there is still so much work to be done to ensure that the Act is fully implemented and enforced. So here are some of the key provisions of the EPA. The EPA defines pollution as the presence in the environment of any environmental pollutant in such concentrations as may or it's likely to create a nuisance or hazards to human beings, other living creatures, plants, properties, or environment. The EPA requires all industries and other establishments to obtain clearance from the CPCB or the SPCB before they can start operating. The EPA empowers the government to take a number of measures to prevent and control pollution, including setting standards for air, water, and noise pollution, prohibiting the use of hazardous substances, regulating the disposal of waste, enforcing environmental impact assessments. The EPA is a complex piece of legislation and there are number of challenges to its implementation. However, the EPA is an important step in the fight to protect the environment in India. Here are the 6 steps. Step 1. Understand the Environmental Protection Act 1986. Step 2. Be able to identify properties that may have impact on the environment. And step 3. Be able to advise your clients on the environmental implications of their property purchases. And step 4. Be able to help your clients comply with the environmental regulations. And step 5. Be able to promote awareness of the Environmental Protection Act of 1986 within the real estate industry. And step 6. Be able to comply with the Environmental Protection Act 1986 in your dealings with clients. So let's move ahead to insurance laws. Insurance laws in real estate business refers to the laws that govern the purchases of insurance policies for real estate transactions. These laws vary from state to state, but they typically cover the following areas: types of insurance policies that are available. There are a variety of insurance policies that can be purchased for real estate transactions, including title insurance, homeowners insurance, and liability insurance. Requirement for purchasing insurance policies. In most cases, both the buyer and sellers of the property are required to purchase insurance policies. The specific requirements vary from state to state, but very typical include requirements for the type of insurance policy, the amount of coverage, and the name of the insurer. Responsibility of the parties involved. The parties involved in real estate transaction have different responsibilities when it comes to insurance. For example, the buyer is typically responsible for purchasing homeowner insurance, while the seller is typically responsible for purchasing title insurance. Dispute resolutions. If there is a dispute between the parties involved in the real estate transaction regarding insurance, the dispute is typically resolved through the courts. It is important for real estate agents to be familiar with the insurance laws that apply to real estate transaction in their state. This knowledge will help them to advise their clients on the different types of insurance policies that are available, that requirements for purchasing insurance policies, and the responsibilities of the parties involved. Here are some of the most common type of insurance policy that are used in real estate transactions. Title insurance. Title insurance protects the buyer of the property from any defects in the title of the property. This means that if there are any problems with the title, such as a line or a defect in the chain of title, the title insurance company will pay for the buyer's legal fee and any other costs associated with resolving the problem. Homeowners insurance. Homeowners insurance protects the homeowners from financial losses that are caused by damage to the property or by liability claims. This type of insurance typically covers the damage caused by fire, theft, windstorm, and other events. Liability insurance. Liability insurance protects the homeowner from financial losses that are caused by accidents that occur on the property. This type of insurance typically covers claim for personal injury and property damage. It is important to note that the specific type of insurance policies that are required for a real estate transaction will vary from state to state. Therefore, it is important to consult with an attorney or a real estate agent who is familiar with the laws in your state. So here are the 6 steps. Step 1. Understand the insurance law that apply to real estate transactions. Step 2. Be able to advise your clients on the different types of insurance policies that are available. And step 3. Be able to help your clients purchase insurance policy. And step 4. Be able to track the performance of insurance policies. And step 5. Be able to advise your clients on when to renew their insurance policies. And step 6. Be able to comply with the insurance laws in your dealings with clients. So number 12 will be your Consumer Protection Act 2019. The Consumer Protection Act 2019 CPA is an act of the Parliament of India that was enacted on 20th July 2019. The CPA repealed and replaced the Consumer Protection Act of 1986. The CPA is a comprehensive law that provides for the protection of the rights of consumer in India. The CPA defines a consumer as any person who buys any goods for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment and includes any user of such goods. The CPA establishes a 3-tier consumer protection machinery consisting of district consumer disputes redressal commissions DCDRCS, State Consumer Disputes Redressal Commissions SCDRCS, National Consumer Disputes Redressal Commission NCDRC. CPA also provides for various consumer rights including the right to be informed, the right to choose, the right to safety, the right to be heard, the right to be redressal, and the right to the consumer education. The CPA is an important piece of legislation that has the potential to protect the rights of consumer in India. However, the CPA is a still relatively new law and it remains to be seen how effectively it will be implemented. Here are some of the key provisions of the CPA. The CPA establishes a new Consumer Protection Authority, the Central Consumer Protection Authority CCPA, which will have the power to investigate and take action against unfair trade practices and misleading the advertisements. The CPA increases the pecuniary jurisdiction of the consumer courts, meaning that they can now award larger compensation to the consumers. The CPA also introduces a new concept of product liability, which means that manufacturers and sellers will be liable for any harm caused by their products, even if they were not negligent. The CPA is a significant step toward in the protection of consumer rights in India. However, it is important to know CPA is only a law and it will only be effective if it is properly implemented and enforced. Here are 6 steps. Step 1. Understand the Consumer Protection Act 2019. Step 2. Be able to identify and resolve consumer complaints. Step 3. Be able to help your client file consumer complaints. Step 4. Be able to represent your clients in the consumer court cases. And step 5. Be able to promote awareness of the Consumer Protection Act 2019 within the real estate industry. And step 6. Be able to comply with the Consumer Protection Act 2019 in your dealings with clients. There are just a few of the legal and regulatory requirements that you as a real estate agent in India must comply with. By understanding those requirements, real estate agents can help to ensure that their businesses are successful and that their clients are protected. In addition to these requirements, real estate agents should should also be familiar with the following. Local laws and regulations govern real estate in the areas where they are operated. The ethical standards of the real estate industry, latest trend in the real estate market. By staying up to date on these matters, real estate agents can increase their chances of success in the competitive real estate market. So we have come to an end of this free mentoring session and legal and regulatory requirements. I am sure that you will be implementing these shared steps. If it is inspiring and useful, then share it with your loved ones so that everyone can have individual independent business growth. If you have not yet subscribed to my channel, please subscribe. If you are really serious to build your real estate business, then click on the link in the below post or WhatsApp to this number to learn more about one-to-one mentoring and coaching, and also about new courses that are being launched to help you build a thriving real estate business and create wealth, financial independency and security to your family. Okay, then thank you so much once again for tuning, and I see you with a new video. Be awesome and keep flourishing to your growth. I am Farah, your real estate business coach and mentor. Well, before I wrap up, I want to share few things here. Some of the websites that I use to collect data for this legal and regulatory requirements for real estate agents in India. National Association of Realtors, NAR. The NAR is a trade association that represents real estate professionals in the United States. The NAR website has a section on legal and regulatory resources for real estate professionals. Real Estate Institute of Australia, REIA. The REIA is a trade association that represents real estate professionals in Australia. The REIA website has a section on legal and regulatory resources for real estate professionals. Canadian Real Estate Association, CREA. The CREA is a trade association that represents real estate professionals in Canada. The CREA website has a section on legal and regulatory resources for real estate professionals. Ministry of Housing and Urban Affairs, Government of India. The Ministry of Housing and Urban Affairs is the government agency responsible for housing and urban development in India. The ministry website has a section on real estate laws and regulations. Locktopus. Locktopus is a website that provides legal and news resources. The Locktopus website has a section on real estate laws and regulations. Bar Council of India. The Bar Council of India is the statutory body that regulates the legal professions in India. The Bar Council website has a section on real estate laws and regulations.